Good evening and welcome to the September 16th, 2020 Burbank Police Commission meeting. I'd like to call the meeting to order. Can we have roll call, please?
Commissioner Chapman?
Here.
Commissioner Cohen?
Here.
Commissioner Ellman?
Here.
Chair Kobaisi?
Here.
And Commissioner Vest is absent.
Okay, thank you. Now, everyone in the chamber, would you please rise for the flag salute? Okay, we will begin with commission announcements. Before I get that, let me just remind that the public comment period will be upcoming in a few minutes. To speak during that period, please call 818-238-3335. City staff will answer the phones and announce speakers in real time to the chair when the public comment period begins. Again, that number is 818-238-3335. So we'll begin with commission announcements and reporting out by commission subcommittees. Are there any announcements from any of the commissioners? I see none. I'll just report out that I've been attending the NACOL conferences online, and that I've also reached out to the BUSD for comment on their SRO program. And that's that. We'll go to, we have a commissioner that would like to make a comment. Commissioner Ellman?
Also been attending the Nicole conference seminars at noontime. Thank you.
Any other commissioners? Okay, moving forward. Oral communications. The callers, anyone that'd like to comment on anything on the agenda, you have 3 minutes. Number is 818-238-3335. Do we have any callers? We have one caller at the moment. Go ahead.
Our next caller is Eugene. Eugene, you're live with the Police Commission.
Okay. Hello, my name. A few comments. One is we had a Senate Bill 731, and I got 2 robocalls. I don't know what organization it was, but it was for police reform and accountability. I was surprised that somebody put a lot of money in robocalling me and gave me twice. Luckily, I don't know if that helped, but it got defeated in the legislature. And then, then we have these, LAPD and the Sheriff's Department. They're putting in millions and millions of dollars for public relations. So I think we got these organizations, probably police unions, and we have these police departments putting up lots and lots of money to influence legislation. And I think that's a danger. I think that's a big problem because they want to get ahead of the story. And I think we have to watch that in Burbank because we had this independent agency said the police should write the report about a crime or that an incident that they're involved in, and not look at the video first. And I'm you know, the police department and the police union is trying to spin it one way, and then you have the other side trying to spin it the other. And where's the truth? And I hope we don't fall into that trap in Burbank. I really hope we don't fall, and I hope we have a good public relations that really, and the police union that really wants the officer to write up. I mean, just on the face of it, that's what it should be, to write up the incident first and then see the video and not spin it. So thank you very much. Bye.
Thank you. Do we have any other callers at the moment? Another caller? Okay.
Our next caller is Heather. Heather, you're on live with the Police Commission.
Thank you so much. Hello, everyone. Good evening, Chair Kabasi and everyone else. My name is Heather Robb, and I'm calling. I was glad to hear in your initial comments to hear that BUSD is going to weigh in on SROs. I learned a lot at last month's commission meeting about SROs and the MHET program. But I was disappointed to really only hear from one side of the issue, just BPD's side of its, on its perspective on its own programs. I really hope that going forward we'll hear more perspectives on these programs and more voices represented in the conversation so that we can have balanced recommendations coming from this commission. I also wanted, just looking at this evening's agenda, I hope that item G2, which is progress update on OIR's recommendations for the annual audit, I hope that that includes an update on recommendation 7, which of the OIR, which stated that BPD should continue exploring interim methods to assess officer compliance with expectations for non-discriminatory enforcement. That's in advance of RIPA going in 2023. And the department's own response said that they would be looking at interim methods. They said they're exploring other resources implemented by other law enforcement agencies, such as Long Beach Police Department, to assess officer compliance for non-discriminatory enforcement. So I hope that that will be included in that update. I think that that is of the utmost urgency and needs to happen before 2023. And I also hope that in item G1, the disciplinary process would include, as the previous caller discussed, the other point of the OIR, which is that officers should not be allowed to watch tape before making their statement. It's just not fair. That's plain and simple. It's not fair. So those are my comments. Thank you so much.
Thank you. Next caller. Any other callers? Okay, no callers at this time. Again, if anyone wants to call, the number is 818-238-3335. In the meantime, would it be appropriate for us to move along to the next topic? Okay, so we will proceed to commission response to the public comments. Are there any commissioners that want to respond to any of the comments? I don't see any. I'll quickly respond. I'm not sure how to respond to that first caller. That was it's got defeated. I kind of get what you're getting at, but I don't know how that applies directly in Burbank at this point. I'll look into that further. To Heather, everybody that we bring up to do a presentation, if anybody, any member of the community, a business, an organization, a citizen sees that, there's another perspective that they'd like to share, anyone is welcome to request to be agendized. We haven't turned anybody down. We've reached out to several organizations, Black Lives Matter included, and everybody gets an opportunity to give their perspective. And BUSD will have an opportunity to weigh in. We're working on that now. So hopefully by next commission meeting, we'll have some perspective from them as far as the SROs. That's all I have in responses. Commissioners, anything else to add? Okay, then we will move on to approval of the minutes from August 19. Any motion to approve? I need a commissioner to acknowledge somehow, raise their hand, or Commissioner Ellman. I can't even see him anymore. He's back. Is there a
I
motion?
said I move to approve the minutes.
Okay, we have a motion and a second. Any second? Did I see a second? Commissioner Chapman? Okay. And all in favor? None opposed? Motion passes. Minutes are approved. Okay, first item of business, a presentation and discussion on the disciplinary process and the amount of transparency. Wait, is there another caller? Okay, we'll take that call. Sorry, Lieutenant, we'll take that call and we'll get right back to it.
Our next caller is Layla. Layla, you're on live with the Police Commission.
Hi, my name is Layla Farouzan, and I'm just calling to second the request for an update on the OIR recommendation relating to the fact that officers should not be allowed to view the video of an incident before giving their statement, just in terms of fairness and in terms of building that trust and transparency with the community. It would go a long way, not to mention I just feel it would be more accurate. And I also would like an update on the possibility of, it's been discussed already, of reporting the data disaggregated by race before it's required in 2023. Again, would go a long way towards building that trust with the community, to present that transparency and show good faith that the department is really committed to non-discriminatory policing. So thanks very much.
Thank you. Any other callers? Okay. This time we're going to go back and stay on track here to presentation and discussion on the disciplinary process and the amount of transparency related to that process. Lieutenant Adam Cornelis.
I've been assigned there a little over 7 months now. I was asked tonight to come in and give a presentation regarding our disciplinary process and transparency related to that. So I'd like to start off with just a little overview of the discipline process, laws and policies that are in place that govern that. We have policies within our own police department. Our policy 1020, personnel complaint procedures, covers that. There's city administrative procedures that cover the discipline process, along with the MOU between the city and the Police Officers Association. In addition to that, we have state law, commonly known as POBAR. It's Government Code Sections 3300 through 3313. It's the Public Safety Officers Procedural Bill of Rights. And that sets rules, basically the framework for how we conduct internal investigations, how the disciplinary process works. That also establishes a 1-year limitation, a statute of limitations on our investigations with some exceptions, things like criminal investigations that are ongoing, or if there's multiple agencies involved, workers' comp, fraud, a couple other exceptions to the 1-year time limit on our investigations. So speaking about complaints and personnel investigations, we basically divide them into 2 categories: community or citizen complaints that are generated externally from the department, and the potential sources there are pretty much any way that the public communicates with us. They can come in and fill out a complaint form in the lobby. We'll take complaints by phone, we'll take complaints in person, by email, by website, by mail, third party, anonymous. If there's a complaint made, we take it, we investigate it. We also have personnel investigations, which are generated internally, and those could come from employees who report something that concerned them, something that they believe to be misconduct or violation of policy. It could be something where a supervisor reviews an incident and has a concern about some sort of violation, or even our critical incident review board looking at critical incidents like a use of force or a vehicle pursuit, where on their review of it, they believe there may be a policy violation, and they could generate an investigation out of that. Once that complaint's been generated, the investigation process begins. Basically, at the end of the day, all of our complaints, personnel complaints or outside, come to the deputy chief's office for review. He'll review and make a determination on assigning them. They can be assigned either back to the direct supervisors or the chain of command for the officers involved, or they can come over to internal affairs, or they can even be generated and put outside to an outside investigator or somebody at the captain level. And what decides that is basically the complexity of the investigation, maybe the severity of the allegations, the potential discipline that could be weighed, and then also the rank of the people that are involved. The investigations are conducted. Every investigation is different, much like a criminal investigation, but generally it's going to involve interviews, reviews of all the documents, reviews of all the recordings, and the progress on that, even if internal affairs even if we're not conducting the investigation, we monitor the progress to make sure that we're going to be within that 1-year statute and that we don't have a misstep where things aren't getting done. To do that, we have a couple databases in place, IA Pro and Blue Team, which helps us track progress and gives us a roadmap of our complaints that have come in and where we are with them. Once the investigation has been completed, it's reviewed and approved by the chain of command, going all the way up to the deputy chief or the chief. We do the review and update of files to make sure our files are up to date with where the investigations are in the disciplinary process. And then once the investigation's been completed, there's a letter sent out to the complainant from the chief's office advising them of the outcome, giving them a personalized update on what happened with their investigation so they aren't just left wondering after they've made this submission to us. So when the investigation's been completed, there's basically 4 potential findings on any allegation. We have an unfounded allegation, basically saying that based on the investigation, the act that's being alleged did not occur. Could be exonerated, saying that the act that was alleged did occur, but that it was within policy. Not sustained, which is essentially saying that there's insufficient evidence to show one way or the other. We can't determine whether there was a violation of policy or not. Or sustained, which is saying that the act alleged did occur and that there was a violation of policy or some kind of misconduct. So there are different levels of discipline. We have verbal counseling, written reprimands, which is basically a written notice that's going in their personnel file, suspension, where they're getting days off without pay, demotion in rank, and the highest level of discipline we have in the organization is termination, where they're going to be separated from employment. Other than termination, any of those levels of discipline can also include a component with some sort of directed training or some sort of mandated management sessions through our employee assistance program, basically to say, you're being disciplined and we want to work with you to make you do better the next time. So it can address, if there's some issues there that need to be addressed, they can be addressed that way. So an overview of the discipline process. Basically, the discipline process begins with a sustained finding on any allegations. Our command staff is going to review the incident and determine a proposed level of discipline for the officers that are involved. That's going to involve a review of their personnel file, an overview of the incident itself, and then any considerations for progressive discipline, which is what we'll talk about a little bit later. But basically, maybe getting a higher level of discipline based on previous incidents. Once that level of discipline has been determined, there's a notice of proposed discipline that's written. That is reviewed by the City Discipline Committee, which includes representatives from the City Attorney's Office and Management Services. They'll review the proposed discipline, review the investigation, review the employee's personnel package, and their overall goal is to basically be a third party, an independent third party to look at it, make sure the investigation's complete, and then also their goal is to make sure that discipline is consistent throughout the city, that the police department isn't coming in soft on things and another department is coming in at a much higher level. They want things to be consistent across the city. Once that notice of proposed discipline has been reviewed and approved, it's going to be served to the officer, basically as a notice that there has been a sustained finding in the investigation and that this is the level of discipline that's being proposed. Following that, they have an opportunity for a pre-disciplinary meeting with the command staff, known as a Skelly, in which they can present their side of the story or there can be some back and forth between them and the command staff about that specific incident. Following that, there will be a final determination from the command staff about what discipline will be, and the officers are given a notice of final discipline after it's been reviewed by the discipline committee, and discipline will be imposed from there. Following that, if the employee still disagrees with the level of discipline, they do have the opportunity for arbitration, and that's through a process with the MOU. So speaking of progressive discipline, any formal discipline becomes part of the employee's personnel file, and a review of that is part of the aggravating or mitigating circumstances that are taken into consideration for discipline in any incident. Best example I can think of just quickly would be if we have a car accident and one of our officers not paying attention, rear end somebody, causes significant damage. We have one officer who's been with us for 10 years and clean driving record, has had no at-fault accidents. They may get a certain level of discipline. Officer B has 4 at-fault accidents, and one of them they've caused significant damage before. They're going to be looking at a higher level of discipline based on the same incident. So it's progressing in order to address the individual officer and any missteps they've made. So speaking of transparency, the transparency of our discipline process and our personnel files is governed by penal code sections. So PC 832.7 basically identified all personnel records for officers as being confidential. They are subject to discovery in court proceedings, commonly known as a pitches motion, where an attorney for one side can make a motion to have the officer's personnel file reviewed to see if there's items in there that would be of concern for the current case, and that can be reviewed by the judge in camera. The judge will make determinations on what would be relevant or not and authorize that to be released as discovery. In 2018, we had Senate Bill 1421 that was passed, and that modified 832.7, and it made certain items of a personnel file public record. Those are going to include reports, investigations, or findings concerning any incident with a discharge of a firearm at a person, what we term an OIS, any use of force resulting in death or great bodily injury, any sustained finding of sexual assault against a member of the public, and any sustained finding of dishonesty related to an investigation of crimes or misconduct. So that's an overview of our discipline process and the transparency there. If there are questions, I will field what I can.
Thank you for that presentation. Any of the commissioners have any questions regarding this presentation? Any questions for the lieutenant? We have one from Commissioner Ellman.
Yes, sir.
Yeah, my question is this. With all processes, there has to be a paper trail. And my question is this. If a resident walked into the lobby of the police station and went and wanted to file a complaint against an officer, when is their complaint entered into a system, and does that resident leave the police station with a report number?
So I'll answer that. If they come into the lobby and want to make a complaint, the complaint will be taken directly. We have a complaint form, and what will happen is the supervisor will talk with them, they can either fill out the complaint form themselves, or the supervisor will fill it out for them as they talk. The supervisor is going to write a memorandum also that will be forwarded with the complaint form. The complaint form is a triplicate form, so they will get a copy of that, so they have a written record of their complaint being received, basically a receipt. As far as it generating a number, it's usually a couple days for it to be a number to be generated to attach to it, because it goes through a process before it comes to us, and I are the ones that generate the report number for it. But there is a paper trail of a memorandum and the citizen having a copy of their complaint in writing when they leave the station.
Thank you very much. Great.
Any other questions from commissioners? Okay, I have a couple. that are kind of clarifying questions because people, I guess, saw this topic and I got some calls with questions about it. So I just wanted to see if you can give me a brief, because these could get lengthy, answer on. So one of the questions was, why can't we just fire somebody right on the spot? Why can't we do that? And is this a Burbank PD policy, or is this the state?
So that is part of what is governed by POBAR, and that does define the process that we have to follow in order to impose discipline up to and including termination. If something that's been alleged or there's sufficient concern that we think it's this severe, somebody can be suspended or somebody can be suspended without pay during the investigative process. But as far as we think something happened and termination being immediate, that is governed by state law. That's not just particular to Burbank.
Exactly. That's the point I wanted to make, because I think people see it as we're dragging our feet kind of thing. Maybe it'll blow over. I don't think people really realize that it's not necessarily up to the chief to just do it so there's a procedure we have to follow, and on top of that you have city procedures and things like that you have to also include. But at the end of the day, you're following the law, correct?
Yes. Correct.
And how you do that.
And those laws were put in place for a reason too. If you go back in some history, there was not necessarily here, but throughout the government, there was a history of some politically motivated terminations. That's part of the reason that POBAR is in place.
And you still report all of these things to the Department of Justice, correct? I mean, whether your findings are sustained or unfounded, does that happen annually still?
Correct. I believe it's annual. I've been in the spot a relatively short period of time, so I haven't generated one of those reports yet, but I believe it is annual.
And all that's available for the public to see, I know, on the DOJ website. So
Correct.
If it's not available on our website, they can certainly go there and see that.
Yes.
And my final question on the disciplinary process is, when you get this complaint, let's say you get 3 or 4 complaints and they are either unfounded or you find them sustained. At what point does any of this, a pattern or anything, show up into a personnel file?
The pattern's going to show up as the complaints come in.
Okay.
They are, regardless of what the findings are on a complaint, that does become part of the IA Pro record. And if we're talking about a pattern, IA Pro also has a feature that they call it an alert. If there's some concerns because of a number of incidents involving a certain officer within a certain time frame, it generates basically an alert saying that we should take a closer look, or just do a review of that officer's activity and see if there's anything that should be of concern.
So,
Yes, sir.
So I'm going to help him out. He did a great summation of the disciplinary process.
Yes, he did.
But we also have a redundant process. We do an annual audit of all our risk management issues. So use of force, pursuits, claim for damages, personnel investigations. So if there is an individual that has an inordinate number of those high-risk issues, they are then again evaluated to see if there's a trend or pattern of behavior. We have done this for the last 3 years, and our auditor or supervisor that reviews all those cases. So you have the initial investigation that's investigated, and that review process. Then we will have our auditor review those investigations to include viewing every video, all the digital evidence. So body-worn camera, in-car camera, the Puma devices, and then I will meet with the command staff and the chief of police to see, to make a determination if there is a pattern of behavior that is concerning. To Lieutenant Cornelius' point, we're going to get prompts prior to that, but we do have a redundant process. The third process to that is OIR. We share that document with OIR, so if we have a high utilizer, they know, we know, and the high utilizer, it may be unfounded, but is it problematic behavior? So we monitor that. So the respective commanding officer is going to monitor, lieutenants, sergeants are also going to monitor. So this process is really a redundant process. Does that provide clarity?
Partially, yeah. I want
Okay.
to follow up with this. So if there's an unfounded or let's say a not sustained, I think, Lieutenant, you said it does somehow make it into their personnel file, or I just want some clarification on in two directions. So we would catch, let's say, someone who was having a pattern, but also, does it hurt a person who gets wrongfully accused of something if that unfounded ends up in their file?
Okay, so there are some overlapping questions. Every IA, the outcome is memorialized for the duration of that officer's professional work history here and will stay memorialized. So if it is unfounded, it's still memorialized, and we can review that if there's all unfoundeds. If there's not, the category that we pay attention to is not sustained. So if you have not sustained, not sustained, not sustained, not sustained, that is a organizational red flag. Unfounded, exonerated, even sustained, we can say with certainty that we understand behavior and outcome. Not sustained falls into that other category. Does that answer your question?
That answered that. That was my concern, is that non-sustained, that shows up as a pattern, and you've got that, you said, kind of a triple layer there with the IAA, the command staff, and then with OIR.
Correct.
Looking at
Our internal audit that we do annually. So we look at every employee in the organization, and essentially we look at the metrics as far as the number of uses of forces that they have been involved in, the number of pursuits, the number of personnel investigations, claim for damages, and if those numbers are higher than the norm, then we look at that group of individuals, and it's not a cursory look, it is a detailed look. That investigation for that auditor takes 2 full months. Typically, there's about 200 hours, 125 to 150 hours associated with that audit.
Does that audit then end up in their file, or is there like a reduced?
It depends. If everything is vetted out, where there is no pattern, and there's no need for further action, then we just move forward. But again, that is shared with OIR. They typically comment on it in their annual OIR report, and if there was a red flag for them, we would certainly hear about it. Not only do I review it, the command staff reviews that report, and the chief of police. So if there is a concern, we typically jump on it right away.
Okay, thank you.
Okay, and I apologize for stepping on Lieutenant Cornelius, but
he did an excellent job.
You know what? He works for me. He's going to be okay. Yeah. Okay.
Very thorough. Thank you.
Chair Kobayashi, if I can jump in here for a moment
Yes, go
before
ahead.
Lieutenant Cornelius comes back. So I want to make sure that we are all using the same terminology as we understand and have this discussion. You've been asking whether these not sustained and unfounded investigations end up in a peace officer's personnel file. When we talk about personnel files, generally disciplinary issues go into the personnel file, the official personnel file that is kept by the city. Cases that are not sustained or unfounded may not end up in the officer's personnel file because generally only completed disciplines end up there. They are nevertheless memorialized in different systems that the police department has to keep records of these cases. And sometimes what happens is, whereas the investigation determined a not sustained, where we just couldn't tell one way or the other, where it may not have risen to the level of a formal discipline, it will flag behavior that might call for additional training, that might call for, so when we say additional look at, while there may not be formal discipline because nothing was sustained, there may still be a recommendation for training based upon the what's happening with that officer. If they get multiple complaints over a certain type of allegation, but we can never have enough evidence to actually sustain the charge, they may nevertheless raise issues of training for that particular officer, so that, again, the police department has an opportunity to try to intervene early when they start to see issues occurring. But it's a very different thing to say that something ends up in any employee's personnel file, because that personnel file, the official file kept by the city, is reserved for disciplinary matters that have been sustained where the city takes action, progressive discipline on that particular case. And the other thing I wanted to add, in addition to state laws that govern disciplines, the city has a memorandum of understanding with our Burbank Police Officers Association. And within that contractual document, there are also terms of how a discipline should be conducted and implemented, including progressive discipline, because employees, not just peace officers, but all employees have due process rights, which goes back to one of your initial questions as to why can't we just fire somebody if an allegation comes in and the allegation is serious enough. The reason why we can't just fire police officers or somebody who works in the clerk's office or a trash truck driver, any employees, because all employees have due process rights. They have rights pursuant to the MOU, and they have rights pursuant to state law. I apologize. My internet connection is not very good tonight, and so I'm glitching in and out. So for most of the meeting, I'll probably have my video turned off so that I can have better audio coverage. But I am here in case you have any follow-up questions.
Thank you. I will have one. I do have one follow-up question for you. So,
Yes.
The memorialized actions.
MOUs? I'm sorry.
The memorialized
Disciplinary
actions for
cases?
the investigations for the sustained or the unfounded that are in a separate file for the city, not the employee's file. Those other ones, are they ever open to Pitch's motion?
So when I speak about the police department memorializing internal affairs investigations, regardless of whatever the result is, the police department has a system called IA Pro. Anytime a complaint comes in or an investigation is generated, it is documented in that program so that they always have a record of what's happening. When you talk about Pitch's motion, so for our listening audience, prior to SB 1421, the only way to get information about a police officer's personnel records, which is sustained complaints, right, and disciplinary actions that have been taken against the police officer, was to go to court and file what is commonly known as a Pitch's motion, where a judge makes the determination that there is information within the personnel file that is relevant to whatever case is before the court. And it's the judge that makes that determination and orders the city to either release certain information from the personnel file or not. And that was the only way to get into a peace officer's personnel file. SB 21 kind of changed that a bit. And so now there's some information you can obtain just through making a Public Records Act request. It only covers certain types of disciplinary matters. It's not every every allegation and sustained discipline is open to that. It's only particular ones if you read SB 1421. So when you talk about the Pitch's motion, Chair Kobaisi, if a judge grants the Pitch's motion, even without the IA Pro, the judge only grants certain information to be released. They don't release the actual entire personnel record to whatever party is making the motion. only certain information gets released. So you wouldn't have access to IA Pro, even if you got your pitches motion granted. It would only be certain codified information that gets released through the pitches motion.
Thank you. Commissioners, any other questions? Commissioner Chapman.
Yeah, I've got a couple. In the, I guess iPro was called, system, is there a account made of the number of allegations that our officers received over a year's period? And then at the other end of it, is there just for numbers, or how the dispositions was? Is there a kind of like, do we have 5 complaints a year, 100 complaints a year?
So IA Pro does track every complaint that comes in and every allegation associated with each complaint. So we can run a report on an individual officer when we're looking at number of complaints or allegations, or we can run a report overall for the department. If we're looking at how many complaints per year we're getting, every allegation, every complaint is tracked, and it's all it's in a searchable format in the program itself. I would say on average, having looked at some previous years when I was assigned here, we're averaging around 50 complaints or investigations per year, give or take.
You have that internally. Can the public see how many complaints that we have a year and the disposition of them?
We do release a report on that every year. That comes out through our PIO office. So we did release one a couple months ago for last year. I believe I believe that's on the website.
So it's going to be annually updated?
Yes.
Okay. And thank you very much for your presentation here. Ms. O had brought up something, and it kind of made me wonder about the status of sharing information between departments. For example, when our department goes to hire somebody from another department, do we have access to do we have full access to the history of them from another department?
Yes.
California.
I just came out. My previous assignment was in our Personnel and Training Bureau, so I ran the hiring process. And part of what we do in the hiring process is the candidates sign a waiver with us, basically authorizing the release of all their personnel files at all of their previous employers, law enforcement or not. And we visit their employers directly with that waiver, and our background investigators sit down and go through the entire personnel file.
Great. So
on each candidate, regardless of their position.
And that's true of any department in California?
We've sent people to Hawaii. We'll send people. My background investigator was reluctant to go, but we were willing to send him to Hawaii to go and do a review of somebody's file. We'll go anywhere in the country.
But Mr. Chapman, to add to Lieutenant Cornell's answer, without the waiver signed by the applicant, we would not have access to that person's personnel file. It's only through the waiver that we can get it. Even with SB 21, only certain information gets released. So if I follow your question correctly, if, let's say, for example, we are thinking about hiring somebody as a lateral from the city of Glendale, or even if we weren't hiring someone, some incident occurs with an officer in the city of Glendale, can the city of Glendale share that information with the city of Burbank? Or if it was Burbank, vice versa? The answer is no, unless it's information that is releasable because of SB 1421. The general rule still is that police officer personnel records are confidential. So unless it falls within the exception of 1421, the only way to get to a police officer's personnel file is, number one, if they sign a waiver letting you have access to it. Number two, a pitches motion has been filed and a judge has granted limited access to some information within that police officer's personnel file that you are seeking. or it falls under the exceptions of 1421. If it doesn't fall within one of those three categories, the general default still is that the police officer's personnel file is confidential, and we could not just release the information because we thought it was important and wanted to.
I'm not sure I'm looking for the information to be released publicly. I'm looking at a little different level. If in the hiring process, does our department have, with some signed waiver, have access to records from other departments?
Yes, through the waiver. Because of the waiver, we get access to their personnel records. But let's say we had an applicant who didn't want to sign the waiver. If they didn't sign the waiver, likely, we're not going to hire them because we don't know what their background is, but we would not have the ability to look into their personnel record from whatever prior employer they had because they didn't sign the waiver.
And for clarity, if they don't sign the waiver, they're not getting hired. Their application process is going to stop right there.
I'm going to go back to Mr. Cornelis. One thing that you mentioned was that there were about 50 complaints filed over a year period. Do we know what the disposition of those complaints was? How many held? How many were?
I would not be able to quote you off the top of my head from the last year. It is on the website, what the disposition is.
That is true. Okay.
Yes.
Okay, great. Thank you.
Yes, sir.
Any other commissioners? Okay, seeing none, we will proceed to the next presentation.
Thank you.
Thank you, Lieutenant. Presentation and discussion, progress updates on OIR's recommendation for the annual audit, Deputy Chief Mike Albanese.
How are you? And just to add clarity for the website, so if you go on there, we average about 50 plus investigations a year. There may be multiple allegations with each investigation. So when you look at the outcome chart, as far as how many were sustained, not sustained, unfounded, or exonerated, it's going to exceed the number 50 because we break it down by allegations. So Albanese and Kabasi could be working together, and one investigation, 4 allegations, 2 and 2, typically the same allegations. So it can be confusing. Am I right on that?
Yes, sir.
Okay. So moving forward, as far as the latest OIR report, there's 12 recommendations, and depending on the format that you want, I can go over each recommendation and where we are with each recommendation. So please provide direction.
If you've got them there, we're willing to hear them all in any order you want.
Okay, so why don't we make it easy on all of us, and we'll start with recommendation number 1. And I'll do a snapshot, a summary, and the first recommendation is develop written protocols to ensure continued calculation of the 1-year statute of limitations. So this is resultant from one investigation where there was an issue with the statute of limitations, and this was kind of a big deal. So this has resulted in a policy change so that as the investigation progresses, we are constantly calculating to make sure that the statute of limitations is within that 12-month period. So we could have an investigation where the allegation is something, and we interview 2 or 3 people, and we found out that someone had brought it to the department's attention through a third party earlier, then that statute of limitation is going to change. So it's an ongoing calculation. So one of the other things that IA does, after an investigation is completed, they do the quality review of the investigation to make sure all the investigative benchmarks are met, to make sure that we're in compliance with MOUs, all of that, and that IA may get kicked back to them, to whoever's investigated it, to make sure that it is complete. Part of what IA will do is also recalculate to make sure that the statute is clearly identified. So that was the issue associated with recommendation number 1. And for folks that have an interest, the policy change is 1020.10.1. It's under file status tracking. The second recommendation is working with the city to ensure that we accurately communicate with the complainants as far as the outcome. This also pertains to the same investigation. There was some confusion as far as the statute of limitation. This came out during the pre-disciplinary hearing, and there was a premature correspondence with the complainant that wasn't quite accurate. That has been reconciled. I spoke to that complainant personally. So moving forward, we have another forum to communicate with complainants if there's going to be a delayed outcome because of the pre-disciplinary process. Moving on to number 3, it was proffered that training, counseling, accountability measures that help promote cohesive and effective supervision throughout its management team. This is something that we have been ahead of. We have a relationship with our EAP program, Employee Assistance Program, as far as personal development, professional development, behavior modification, coaching, where you might just not be able to get along with folks. So we have a resource where we can have them be mentored, coached, so that they have better coping skills. They're better people, they're better supervisors, they're better employees, and we have had actually great success with that, and we continue to use that model. So we were a little ahead of the game on that, and that was one of their recommendations. Throughout this process, OIR knows what we are doing because we communicate with them as far as our progress, as far as their recommendations. So we give them periodic updates. Recommendation number 4 was to be have enhanced training as specific to the IA intake process. And we have some young supervisors that may not be as conversant with the intake process. That is, someone makes a complaint, how it is codified, how it is memorialized to investigation. So actually, Lieutenant Cornelius provided training in June 24th, 25th, 26th, 30th, and July 1st for all of our supervisors so that they are more conversant with that process. Recommendation number 5 speaks to the reinforcing the policy as it relates to digital technology. So we got caught in the middle there because we were beta testing several in-car camera, body-worn camera systems, and we still had the Puma system. And in October, we will be a full year onboarding the Axon body-worn in-car camera system. So our compliance rate is, when I wrote the report, it was 97%. We're a little less than that as far as activations, when it meets the threshold, when it meets the criteria for activation. So when does it not meet the criteria? You get a radio call, you go there, no one's there, there's no one to talk to, so you wouldn't activate the device. The compliance rate, our goal is going to be 100%, which is going to be tough to achieve, but you also have equipment issues that were problematic. A couple incidents, we had officers that had docked, charged their device, and a call came out and they left the building and the device was inside. So we look at that as a non-activation. So our compliance is in the high 90 percentile bracket. We're going to strive to touch 100%. I don't know if that's achievable, but we also have rolling audits. We have a administrative analyst that is assigned to the program, and we get monthly updates from the analyst as far as our compliance and activation, in addition to an annual audit. And that the most recent audit was conducted June 8th. Recommendation number 6 speaks to professional language. We had some instances where we had some officers that expanded their definition of tactical language that really wasn't necessary. So we have looked to programs that would help officers during managing incidents where you have difficult subjects. And I think everybody can understand that. If they're intoxicated, if they're emotionally over the top, and to get compliance with difficult subjects where our comportment could be better. So I personally reached out to Cal State Long Beach. They have some programs there. They did not have the program that I thought would be beneficial. Lieutenant Cornelius reached out to other folks. The bottom line is that we have training that is going to be on October 1st that we're going to beta test. This is in addition to a syllabus that we have created, our Cops Bureau has created. And this program had great success in Pasadena. It's called Why Did You Stop Me? And it's a supervisor from Long Beach, former professional athlete, and we are going to beta test that to see if it'll be helpful for our officers to help folks that are challenging during some type of investigation or detention. So we are meeting that recommendation and are moving forward with that. So recommendation number 7, and it was addressed by Layla and Heather when they phoned in, is that in addition to the RIPA mandates moving forward, to be absolutely, totally in compliance, it requires our CAD system to be reconfigured. There was a significant price point associated with that. It required our captain of support services, our record manager, to work with our Tiburon folks to get the compliance requisites in place. That is being done, but in addition to that, and RIPA stands for Racial and Identity Profiling Act. In addition to that, we have an electronic daily field activities report that has 56 different fields that gives us another digital opportunity to monitor, to see if there's any trends, patterns as far as officers detaining, intervening with community members. We can get a snapshot of those demographics and the outcome. So we believe that we are ahead of the required mandates, but it's still a work in progress. I don't want to mislead anybody, but we are working hard to make sure that we're in compliance and that we're monitoring officer activity to make sure that there is no pattern or trend of untoward enforcement efforts. Number 9 was a quick fix. Was a recommendation by Steve Conley from OAR as far as a checkbox on the critical incident review worksheet. When they gave me the heads up on that, we fixed that the next day. So that was completed and done on February 18th. The recommendation 9 speaks to the intake process associated with folks that are intoxicated. We had our jail staff, we had 4 individuals over the course of the year where we had kind of administrative missteps. So that has been addressed. It was addressed directly by the jail staff. We have now a jail manager. We have, in addition to follow-up training from this recommendation, we have annual training, annual in-service training, and moving forward, I believe the next audit period will be fine. Recommendation 10, 11, and 12 are going to be specific to the pursuit policy. And this has been a bit of a journey with us, and this has been a conversation that we have had with OIR as far as our pursuit policy. Our department has a very restrictive pursuit policy. Consequently, if we have officers that are in pursuit and they're trying to assess to see what they have, if it meets the thresholds or criteria to continue with the pursuit, the minute they say the P word, then it's a pursuit. So even if it only goes 15 or 20 seconds, it's going to be fully investigated and it can come back out of policy. And there's there is a request by then, the BPOA and even the command staff to have a pursuit policy that provides clarity for the end user. So all that to say, we've had a journey. We've had a couple working groups. We've had probably no less than 5 revisions to the pursuit policy. The latest revision, the command staff signed off. So once the command staff signs off, then the chief of police would have to sign off, BPOA city attorney. The next day, literally the next day, Lexipol, who is provides direction to law enforcement as far as their policies, had 17 changes to the pursuit policy. So we had to go back. There was revisions to the revisions, and they are in the review process right now. So once us three finish reviewing those revisions, then it'll go to COP, Chief of Police, BPOA, and then ultimately the city attorney, just to make sure that we are not missing anything. And on the high-risk policies, use force, pursuit, we also share with OIR so that they can weigh in. But the Lexipol recommendations are pretty airtight because that is a cadre of attorneys that whose forte is law enforcement and risk management that looks at these policies. So I know I went really, really fast. So if you have any questions, I'm good to go.
Commissioners, any questions? I have just one. Just for clarification, on the camera activations, when we were talking about them and I know when you did the presentation before we had them, there was some discussion of automatic activation. Can you talk just a little bit about that?
Absolutely, and that's a great question. So there's several ways it can be activated. So it's automated when you turn on the red lights. So it's absolutely automated. So it activates the in-car camera, so front and back, or back seat, and then it activates your body-worn camera. So if you go to a radio call, don't activate your red lights, then when you get out of the car, you would have to manually tap to activate your body-worn camera.
So
then one other thing, where's taser? And so if you present your taser, if something happens very abruptly, unfolds very quick, you jump out of the car and you go to your taser for whatever reason, that will create an activation, right? Do you want to pick me up here? I'll give you a chance. Yeah, good. Yeah, go ahead.
Yes, as it stands currently, if the taser is off safe and activated, or if the taser's come off safe, it's basically a Bluetooth connection. It will automatically activate body cameras. I know the department's also been looking at a product through Axon that's basically a device that attaches to the firearm holster, because the taser is made by Axon, the body camera is made by Axon, so they talk to each other. Firearms and holsters not made by Axon, so they have a device to attach to it. So if the officer draws and presents their firearm, it's going to automatically activate the body camera. I know that's in the testing process. I don't know where they're at with that as far as deployment.
Oh, okay, great. Because that was going to be my next question. And just to follow up, the percentages that you gave us, Chief, were they based on manual activation, or do they include the automatic activation, the compliance?
It's all activations.
All activations.
All activations. But what I'm mainly interested in is the body-worn camera, because that's when you're out of the car. In-car camera, pretty straightforward when you turn on the lights, and you can do it manually. So we've had a handful of folks that did not activate their camera. Typically, we discover that during the review process of the use of force, where we have maybe 4 officers that are at scene, 3 of the 4 body-worn cameras were on. One of the officers did not have their body-worn camera on for whatever reason, and we take corrective measures. Our folks know now is that the grace period is gone. The expectation is, unless there is a compelling reason why you can't activate your camera, is that there's a activation requirement. For folks that jump out of the station for whatever reason where it's docked, that's an expanded explanation that may have some merit, so we look at each of those cases individually. But again, our expectation is that we're going to be in the high 90 percentile bracket, touching 100%. I don't know how achievable that is, but that's the goal.
Thank you.
No other
Any
questions?
I see one question from Commissioner Ellman. Commissioner Chapman, did you also have a question? No, okay, so Commissioner Ellman.
Good evening, Chief. My question goes back to recommendation 9, but I'd like to expand it a little. This comes from one of the Nicole seminars I attended. Can you discuss a little about detention of individuals with disabilities? The example they were used at the conference was people who are diabetic and need insulin.
So this recommendation is more specific to a jail setting, but to your point, and I think I heard part of that presentation as far as officers understanding behavior. And it is challenging. In fact, we just got, Sherry, today, cards on autism, or specific on autism, where you have behavior, acting out behavior that may initially appear to be threatening or may have a criminal tone to it, but it's different behavior specific to autism. We had an incident with a diabetic whose insulin level was so low, the acting out at the library, he was throwing stuff around and just acting bizarre. And as soon as we were able to control him, a quick assessment, he was having a diabetic reaction or insulin reaction, and they gave him some orange juice, and all that behavior changed. So I'm kind of taking the long way around the answer to answer your question, is that is something that is discussed for first responders, for our communication folks, and for our jail staff during the intake process. If there's a booking process, there's a series of questions that are asked. If there is any behavior that is indicative of curious or odd behavior, there'll be medical attention will be introduced.
Thank you for your answer.
Did I answer your question?
Yes, you did.
Okay, great.
Okay, any other questions? Okay, see none. We will go on to the next item of business. It's discuss and determine topics to be addressed at upcoming meetings. And we do have an ongoing agenda item, so I think that ongoing agenda item is implicit bias training that we're going to try to get, Chief, I think, in November for the implicit bias training.
So we're trying to obtain
Presentation.
a university professor at this time. The first one we approached is not going to be available, but we will have a presentation on implicit bias.
Okay, so we'll keep that on the agenda.
We will.
And then I'm trying to find, I couldn't find it here, but there was a staff report, I think it was staff report A. I don't seem to have a copy of it, but that was the one with the city council's recommendations for us. I have only on my list left federal legislation impact, which we're going to try to put the link that the city attorney gave us an update on that. We're going to try to put a link of that on the website so that folks who want to see that can get that, so we don't have to take that up as an agenda item because that's already available. And we did the last two that we had today. There's only one left, which is BPOA participation in the discussion. I think we can give them an opportunity at the end before our recommendations to maybe see if they have some input into there. But did any of the commissioners have any other items they'd like to see put on the agenda for discussion for upcoming meetings? Anybody? I don't see anything. I think we'll just make a note to go off that staff report if there's any other ones. I know there was a diversity of the commission issue. We can also place that back on there again and tackle that at the end and hopefully come up with the recommendations for the December meeting. Commissioners, are there any additions? I don't see any.
Let me make a comment at this point. If anybody that's watching or listening tonight has a topic that may be of interest, what you can do is call us at 818-238-3200. Again, that's 818-238-3200. And that's our office number. So if you have a proposed topic that has come to mind, go ahead, call that number. And Sherry Nakamura is our executive assistant. She'll pick up that call, and we will forward that information to you, Mr. Chair, for possible consideration. But I do know with the national narrative, we get questions all the time about new topics, things that occur in other jurisdictions. So in the interest of fairness to everybody, if there's something that we have not considered that should be considered for a topic of discussion, then make sure that we know about that.
Thank you. And I'll also follow up. There was one item that's kind of left over from our previous agendas, which was a sort of a community forum or meeting. I wanted to address that because we haven't had one of those because of the COVID situation. And we're trying to wrap up this, but that's still in the works. So at some point in time, we'll get to that. Whether it ends up being virtual or not is a different
and let me add there, had we not had COVID, we would have been out in the community. I believe it was Commissioner Cohen had made a recommendation that we get back out into the community and try to get input at different forums. So we could do that virtually. That is kind of a logistical challenge right now, but our intent on a go-forward basis, as soon as COVID is lifted to some extent, is to go out into the community and have a dialogue.
Thank you, Chief. Now we'll go to the next item, announcements by the Chief of Police.
Okay, thank you. A couple of comments to make about items we'd already discussed. One is on RIPA, which is the Racial and Identity Profiling Act. So it's already been discussed, but I want people to understand that if we could possibly release information right now, we would. The way the system works, this was a mandate via state legislation. The Attorney General's office is in charge of the program, and this would be akin to what I would term an unfunded mandate. So as was previously discussed, we're going to have to change our CAD RMS system in order to gather and compile that information in the proper format that's required by the Attorney General. So if we can do that ahead of time, we will. I know as recently as today, Captain Irving in our records manager, Jennifer Moran, had a discussion with a representative of the Attorney General's office to talk about our going in the proper direction. So that is a work in progress, and if we can start providing that information sooner, we certainly will. Another piece of information I want to make sure that everybody understands. So we talked about the roughly 50 complaints that we receive a year. We actually try to personalize a letter back to the complainant where we detail the disposition of that particular matter. But I know that sometimes, even though through our best efforts, we try to provide a concrete analysis and a rationale, if somebody that is a recipient of one of those letters does not understand, we do have the respective captain's contact information, name and contact information listed. So the whole purpose of that is so that we can engage in a further dialogue if that's necessary to explain what is happening. So again, this is something where we're trying to bend over backwards to make sure that if there are unanswered questions, that we can at least have another discussion. Moving on. In terms of upcoming activities, there was in anticipation, we might be able to have a National Night Out celebration on October 6th. The date on the first Tuesday in August is the reserve date. Because of COVID, we had to cancel that this year. The national organization has selected October 6th. Whether we are going to be able to spin up something meaningful, I don't know. If, in fact, we do something, we will include that on our website. Another activity that people might want to be concerned about is on Tuesday, October 13th, we are going to honor our Rex Andrews Award recipient, which is Officer Ryan Rhodes. We will do that in the afternoon via a virtual presentation to the Rotary Club, and then we will be at council on that night as well. Another activity that is of interest to the community, the cities of Glendale, Pasadena, and Burbank, commonly known as the Tri-Cities, are looking at consolidation of various aspects of police work, which include things like the range, the crime lab, and there are several other identified topics that we're trying to study. So that is a work in progress, and I will keep the public informed of our efforts there. I'd like to briefly discuss crime statistics. We are trending exceedingly well in reducing crime. Year to date, we are down 8%. Traffic collisions are down 24%. And then in terms of our response times, we're less than 3 minutes to emergency calls and less than 14 and a half minutes to routine calls. So we're doing a good job out there, and our response times, in my mind, are very significant because the quicker we get there, the quicker we're able to apprehend or at least respond to whatever the emergency situation is. So I know that our Board of Realtors and other folks in the community try to accentuate both the police department and fire department in terms of response time. So that is a very commendable number. Toward that end, we do have a relatively crime-free city, but what we have noticed is that there are people that come in from outside the city to commit generally property crimes in this particular jurisdiction. So something that I've always said is if you see something, say something. So if you see something suspicious, that means call us so we can respond to the scene. The other piece of that is harden the target, and we still have a lot of people that believe they are in a safe city, and they are, but they don't always lock their cars and lock their homes. So it's little things like that that go a long ways toward hardening the target. So that's something else that I just want to accentuate at this point. And that is it for this evening.
Thank you, Chief. Okay, now is our final period of public comments. 3 minutes per caller. Do we have any callers? No callers? Okay, I will put that number out again and we'll continue. 818-238-3335. And we'll move on to the next agenda item. I'm going to skip over the response to public comments. For now, introduction of agenda items for future meetings. Commissioner Chapman.
Thank you, Chair Kabasi. I just wanted to check. We had a caller in the past, and I wanted to confirm that we had been our police have been in contact with her. That was a woman named, I believe, Carmenita. I just want to confirm that there was a reach out there.
I think we did. I think we covered that last meeting, but Chief, do you want to address that?
Yes, we have spoken to her. I believe the first item that she brought up was at the Joint Council Commission meeting. Chief Albanese, I believe, followed up with her the next day, and anytime that she wants to further discuss any contacts that her family has had with the police department, the door is open. So we have left messages for her to continue to a dialogue with us if she chooses to, and that has not been her choice.
Thank you, Chief. Any other
Thank you.
agenda items? Is there, Commissioner Chapman, did you have an agenda item you wanted to add?
No,
Okay.
that was it.
Okay.
Thank you, Chief.
Any other commissioners' agenda items for our next meeting? Nothing? So we'll continue on. We'll carry on from that list. And if there's something that we missed here, we'll refer back to the staff report with the recommendations from City Council, correct? Do we have any agreement on that? So that we can add anything that we've missed from the previous list, we'll just add it automatically to the agenda. Is that okay, Chief? Okay, thank you. Okay, any callers? Still no callers, so we'll proceed to the next meeting date is October 21st, 2020. If you want to call at that time. At this point, with nothing further, I'll adjourn the meeting. Meeting is adjourned.